So, hello everyone, and welcome to Criminal Law 1, Constitutional Criminal Procedure. Today's topic is plea bargaining and sentencing. So let's talk a little bit about plea bargaining. Now, criminal cases are most commonly resolved with a plea bargain versus a jury trial. Right, so if we look at the data, between 95 and 99% of all felony cases, remember that's a year or more in prison, are resolved by plea bargains, whereas nearly 100% of misdemeanors, so less than a year in jail, usually just small infractions, are plea bargained, right? And the idea is there's several ideas behind this, but especially for misdemeanors, trials are expensive, right? For everyone, for the court system, for the prosecutor, for defense attorneys, and we don't want to go to trial, right? For a misdemeanor, because it's literally just like a minor thing. So we'll generally always do a plea bargain, just because we want to save the time and expense of a non-serious crime and reserve courtroom time for the more serious offenses. Now, that being said, when we talk about plea bargaining basically consists of entering a guilty plea or an Alfred plea, nolo contendere, which we've talked about before, which is I'm not guilty, but I recognize that you have enough evidence to convict me, even though I'm not guilty. Generally speaking, you're going to have to plead guilty. Sometimes they'll let you do an Alfred plea. And what usually happens is this occurs in exchange for dropped or reduced severity in charges, right? So if you plead guilty, instead of charging you with murder in the first degree, we'll charge you with voluntary manslaughter, right? One, you'll never see the light of day if you're convicted of first degree murder. Voluntary manslaughter, you do have an opportunity. Right, so prosecutors will also drop charges, right? So if they charge you with 7 different crimes that kind of originate from the same transaction, they'll say, you know what, we'll drop 6 of them if you just plead guilty, and you only plead guilty to 1, and so you only get sentenced to 1, right? So that's reduced or dropped severity in charges, and or you might be able to plea bargain for a sentencing recommendation, right? So ultimately, sentencing is up to the judge. Now, there are some exceptions, but generally speaking, sentencing is up to the judge. That being said, if the parties agree as to what a sentence should be, then a judge is probably not going to overturn it, right? So what happens is in the sentencing recommendation, the prosecution and the defense get together and to say, okay, if I plead guilty, you will recommend to the judge that I be placed on probation for 5 years, right? Whereas if you went to trial, you could go to prison for 5 years. So sentencing recommendations do play a very large role in how judges function and how courts work. Now, the least common kind of exchange in plea bargaining is a determinative sentence, right? So what this basically is it's similar to a sentencing recommendation. Instead of just being a recommendation, what this is as the defendant, you enter into agreement with the prosecutor as to exactly what your sentence will be. Now, you go in front of the judge, and if the judge agrees, then that's your sentence. Like it's already determined, right? Like that's it. If the judge disagrees, right, and says, no, I'm not going to go that low, then you have the right to essentially take back your guilty plea and go to trial and all that jazz. Again, this is the least common because judges like to have the power instead of giving it all to the prosecutor, but it does happen from time to time. Now, when we talk about plea bargaining, sometimes it kind of feels like it's unfair, right? Because if you're innocent, a lot of times you have incentive to plead guilty. If you're guilty, you have incentive to plead innocent. So it kind of seems like a disconnect. That being said, as noted by one judge, which we talk about in Law and Society, there's a really good quote, and this judge said, "Without plea bargaining, the American justice system would collapse." Right? And so it makes sense if you think about it, right? So, I mean, it could take 1 to 3 years to get to trial for a felony. And that's with 95 to 99% of felonies being pled out, right? So if we gave a trial in every single case, we would be talking that this would, it would be unmanageable, right? Instead of 3 years to get to trial, you're looking at 30 years to get to trial, right? And so that's a really big problem, right? Because just as the number of charges, people arrested in the United States, our incarceration rate is so high, without plea bargaining, the justice system would collapse. Now, beneficially, this theoretically includes kind of 4 benefits, right? The first is responsibility. So if somebody's guilty, they can stand up and take responsibility for what they've done. There's flexibility in terms of we can create a sentence. We can change charges. We can do whatever we need to make the sentence appropriate to what happened. There's convenience. Again, we're avoiding a trial. And especially if we have a determinative sentence, there's certainty, right? So instead of the judge just kind of deciding, oh, this is what you're going to get, you know, going into the sentencing hearing what you're walking out with or what you're going to jail with. Now, so these are kind of the benefits, right? As we talk about also in Law and Society, plea bargaining, especially as it's done in the United States, is largely criticized as what a lot of people call modern day torture, right? And it's rejected by many countries in the world. For instance, like France, you can't plea bargain, things like that. And the idea behind this notion of modern day torture is, you know, if you're tortured, at some point you're just going to plead guilty just to end the torture. You're going to confess, even if it's wrong and you're lying, just to end the torture, right? Well, with plea bargaining, it's very much the same way, right? You may plea bargain, you may say, I'm guilty, even though you're not guilty, just to get out of jail, right? If you're being held without bail, or just to end the process, right? Because having those charges over your head, it is a nightmare. So it's been kind of this equivalent of modern day torture that you will plead guilty just because of how terrible the situation is, not knowing and not really having any control over your future. Now, that being said, when you plea bargain, there's one really notable thing that happens. And that is, generally speaking, you waive your rights to an appeal, right? So the idea is you've pled guilty, so you've agreed that you committed the crime. And so there's really no reason for us to let you appeal. Now, the problem here is, what about actual innocence? Right, so theoretically, if somebody is not guilty of a crime, right, and the prosecutor says, look, if you don't plea bargain, then your punishment could be up to 25 years in prison. But if you plea bargain, we'll recommend 5 years in prison. Well, there's a big difference between those two, right? And that's where the kind of the modern day torture comes into play. But also the idea is, what if this person's innocent, right? They have incentive to plead guilty, because if they are found guilty, instead of looking at 5 years, they're looking at 25 years, right? So generally speaking, you can waive your appellate rights. The idea behind this is if you are factually actually innocent, you would never enter into a guilty plea, which we know is just not true, right? Again, kind of relating it back to modern day torture. If you're looking at a difference of 25 years versus, let's say, 1 year, you're probably going to say, okay, screw it, 1 year, right? Like, especially if you're being held in pretrial detention. But if you're actually innocent, there's not a whole lot that you can do about it once you plead guilty. And the system is predicated on the belief that you will not plead guilty unless you are actually guilty, which we know in a lot of cases is not true. So let's talk a little bit about the constitutionality of plea bargaining. So per the case Brady v. United States, pleas must be entered into knowingly, intelligently, and voluntarily. Right? So to comply with Brady, the entry of a guilty plea, of a plea, is governed by Rule 11 of the Federal Rules of Criminal Procedure. Now, what this generally requires is it requires judges to engage the defendant in a plea colloquy, right? And in this case, the judge is required to inform the defendant of certain things, right? So the judge informs the defendant of the nature of the charges. The prosecutor and judge informs the defendant of the factual basis for the charges in the plea. And this is really important. The judge confirms the plea is being entered into voluntarily, right? So from a 1978 case, we know that prosecutors can somewhat coerce defendants into pleading guilty, right? Saying, well, if you don't plead guilty, I'm going to charge you with something that will get you 50 years in prison. But if you plead guilty, you can walk out today. That's coercion. But as we've interpreted it, at least in the criminal law, is that's not coercion, right? Because again, it's up to you. If you're not guilty, you're going to say you're not guilty. That's the thought process. In reality, is that how things work out? No. That being said, I do want to share with you what a plea colloquy looks like. So hopefully you can hear this. It looks like Zoom has frozen. But this is also on Canvas in case that this isn't working. So what you have here is actually in front of you are the rules that judges have to follow, right? When taking pleas of guilt, no low contendere pleas. So what this does is this allows, it's an outline, but it's of the questions that a judge has to ask a defendant if they are going to plead guilty. Okay, so there was a little problem with Zoom. It froze up, so I don't know exactly what you got to hear and what you did not get to hear. But what we're going to look at real quickly is the guilty plea quilloquy. So this actually comes from a judge's manual on what they are supposed to do and the questions that they are supposed to ask a defendant in order to ensure that a guilty plea is being entered into knowingly, voluntarily, and intelligently. So basically, if you kind of scroll down to 70, you have an outline of what this looks like, right? So you determine on the record the purpose of the defendant's appearance, that is to obtain a statement from defense counsel that the defendant wishes to enter a guilty plea or nolo contendere. If it has not been previously established, determine whether the plea is being made pursuant to a plea bargain of any kind. If so, require disclosure of the terms of the agreement, or if the agreement is in writing, require a copy be produced for the judge's, inspection and filing. Then you have the clerk administer the oath to the defendant. So do you swear to tell the truth, whole truth, and nothing but the truth? Then you begin the questioning of the defendant. Right. So you ask the defendant, do you understand that you are now under oath? And if you answer any of my questions falsely, your answers may be used against you in another prosecution for perjury or making false statements. Say yes, and you move on to 2. What is your full name? You move on to 3. How old are you? Then you move on to 4. And 4 is a lot more important than we give it credit for. 4 is, how far did you go in school? Right? So the more education you have, the more likely it is we're going to say that you're not being coerced into this plea, you're doing it knowingly, voluntarily, intelligently. But let's say you dropped out of school in the 3rd grade and you can't necessarily read or write that well. The judge is going to be really, really suspicious, right? Of like, you okay? What's going on there? You're also going to be asked, have you been treated recently for any mental illness or addiction to narcotics of any kind? Right. And so the idea here is, are you under any kind of drug or drugs that would basically affect the way you're answering these questions? Now, if the answer is yes, you pursue the subjects with the defendant and their counsel in order to determine that the defendant is currently competent to plead. Then you ask, are you under the influence of any drugs, medication, or alcoholic beverage of any kind? Again, the answer is yes. Pursue the subject with the defendant and counsel to determine if it is currently competent. Then you ask, have you received a copy of the indictment or the information depending on how it was filed, pending against you? That is, the written charges made against you in this case. And have you fully discussed those charges and the case in general with Mr. or Mrs., whoever your attorney is, as your counsel? Then are you fully satisfied with the counsel representation and advice given to you in this case by your attorney? Is your willingness to plead guilty or nolo contendere the result of discussions that you and your attorney had with the attorney for the government? Now, again, this is where you pivot. If there's a plea agreement, you ask the defendant, have you had the opportunity to read it and understand it? Has anybody made you any other promises that aren't in this plea agreement? Do you understand the terms? Do you understand that I can reject the plea agreement, right? All that jazz. And you go through these, and there's just a ridiculous number of questions. When we say ridiculous, it's not ridiculous in the sense of it being absurd. It's ridiculous in the notion that it's so very long. But the reason it's so very long and you have to go through so many questions is because when you plead guilty, you are giving up constitutional rights, right? And we want to make sure that, 1, we're incarcerating the correct people, and 2, that you haven't been forced into giving up your constitutional rights. So that being said, what usually happens is courts and judges usually schedule a plea day, right? And on plea day, it's everybody who is going to plead guilty up to that point and hasn't had their own separate hearing. What they do is they bring them in one at a time, and the judge goes through these questions rapid fire. Some have accused judges of not even listening to the answer, because so long as they ask these questions in this order, then they have done their due diligence. And you can see there's a lot of questions. The thing is judges do this so much that they have it memorized. They don't have to look at a piece of paper and ask, okay, now this is the case. Has the government done this? Has whatever done this? They just go through it rapid fire. Do you understand this? Do you understand this? Have you been coerced? Have you been, just rapid fire. Because they do it so much, and they do all their sentencing hearings, or the plea agreement hearings, I should say, on the same day, right? In one sitting. And the idea here is that way the judge can just focus on reciting the issues and just going from there. So that's a plea colloquy. Again, I encourage you to take a look at it. It is on Canvas, so definitely look and see what that has to offer. So kind of taking another look at this, once you enter a plea, so if you plead guilty, things become very much problematic if you want to change your mind, right? Generally speaking, if you decide to plead guilty, or even not guilty, or whatever, generally speaking, it's guilty, you can withdraw your plea at any time before the court accepts it, right? And the court is only going to accept it after they've have you in court and they do the plea colloquy and have completed it and are satisfied with it. Now, if halfway through the colloquy you decide to withdraw your guilty plea, then you are defaulted back to not guilty, and we set up a trial date, right? So pleas can be withdrawn anytime before they're accepted. However, once a plea is accepted by the court, but it's before formal sentencing, a plea may be withdrawn if doing so is fair and just, right? So it's on the defendant to show that they are withdrawing the plea out of fairness, out of justice. Maybe some other facts have come up, something has made them change their mind, besides I don't want to go to jail, that would make the court say, okay, you can change your mind. Now, it becomes exponentially more difficult if the court accepts your plea and has imposed a sentence. Now, this doesn't make it impossible, but you can withdraw your guilty plea if you've been sentenced, if it meets really an impossibly high standard. One, it would result in what's called a fundamental miscarriage of justice, also known as manifest injustice, right? So this is, right, the fact that you took the plea is, even though you knew it and agreed to it and all that jazz, it's fundamental miscarriage of justice. We'll talk about actual innocence in a minute. Generally speaking, like this occurs if the prosecutor does not abide by the plea. So the prosecutor says, yeah, I agree that we'll enter the recommendation that you'll be sentenced to probation, and you get to court and the prosecution says, we recommend 5 years in prison. Okay, like, again, if that's fair and just if you do it before sentencing, but after sentencing, I mean, you had an opportunity to object, an opportunity during the Quilloquy to withdraw, right? Your guilty plea if that's what they were going down the path with. Now, if the prosecutor, after you've been sentenced, the prosecutor says that you're guaranteed to just stay locally, that you're not going to be sent off to a different a prison somewhere far away, and then you get sentenced to a prison somewhere far away, then you can say there's been a fundamental miscarriage of justice. I pled guilty because and was sentenced because the prosecutor said that I would not go to a prison very far away. And in this case, the prosecutor did not abide by their promises, so I can withdraw my plea. Now, generally speaking, at this point, withdrawing your plea is still impossible. What's going to happen is the judge is going to essentially hold the prosecutor responsible in terms of stating, you have to abide by what you said, right? So we require specific performance in these cases. Now, there's policy reasons behind this, right? After sentencing, like, this is very serious. And we want to make sure that we maintain the integrity of the process, right? If you've pled guilty, you've admitted that you've committed a crime. You've had the opportunity to withdraw. You've had the opportunity during the Quilloquy to say that this has been entered into unfairly, unjustly, whatever, and you haven't, right? To that end, that's really serious, right? So the idea here is we don't want the defendant getting cold feet, right? The defendant going, oh God, I have to go to prison for a year, and withdrawing it and just making the thing last longer, right? And we want to make sure that we maintain the integrity of the process. So we go through the whole thing and make sure that it's voluntary, and then you can just withdraw at any time for no reason, well, then there's a problem, right? Now, generally speaking, we're talking about a fundamental miscarriage of justice. What we are requiring is a viable claim of actual innocence, right? So this is, I have pled guilty, I have been sentenced, and then suddenly new evidence emerges that I could not have discovered prior to the sentencing that shows I am actually innocent, right? And again, this is a very, very high, almost impossibly high standard to meet. So, you know, this can even pop up once you're in prison, right? So there are lots of cases where people are in prison and they've pled guilty. So they weren't just sentenced there, but they've pled guilty. So they've given up their rights to an appeal. And new evidence, especially with the advent of DNA in forensic setting in the 1990s, comes forward that suggests you didn't do it. Then you might have a viable claim of actual innocence. And we might say, you can go back and withdraw your guilty plea, even though you've spent 25 years in prison, because it looks like there's a fundamental miscarriage of justice. Now, what happens after that is largely up to the judge and the prosecutor. If the judge is letting you out of prison, then the prosecutor is probably not going to follow up on the trial and retry you. But they still have that right, right? Because theoretically, no witnesses have been sworn, you pled, there's no double jeopardy. So let's kind of shift gears here and talk a little bit about the philosophical principles guiding sentencing. So generally speaking, we have like 5 philosophical principles, right? And if you've taken intro, you've heard these before. So we'll go through them fairly quickly. One of the biggest ones in terms of what guides the United States is retribution. So this idea of retribution can be traced back to the oldest known legal code, that we have found, which is the Code of Hammurabi. And Code of Hammurabi prescribed as punishment for crimes lex talionis, right, which translates into an eye for an eye. Now, if that sounds familiar to biblical, an eye for an eye, a tooth for a tooth, there's a reason. Now, what this does is this provides that punishment is just deserts of a transgression, right? So basically, society is obligated to punish somebody because they have done something wrong, so you're obligated to punish them. But, and here's the but, we say an eye for an eye, it has to be proportional, right? So whatever crime you committed, your sentence, your punishment has to be proportional to the crime, right? So that's why when we talk about the death penalty, for instance, right? We've now relegated the death penalty to aggravated murder claims, whereas before we were talking rape and things along those lines. And largely the idea of an eye for an eye comes into play, right? I mean, if you commit rape, like you are a horrible piece of shit, like you probably should die. That being said, you didn't kill someone. So if we kill you and the other person's still alive, then we violated the eye for an eye. Now, obviously, we're not going to require a physical punishment of being sexually assaulted yourself, even though it's not really a bad idea and you probably will be in prison. But instead, we say, okay, you did this and that equals X units of harm. And as such, we have to impose X units of punishment, right? And so that's theoretically how we get to this notion of what people get in terms of their sentences. Now, another big one in the United States, and this underscores, a lot of why and how we punish is deterrence, right? So deterrence is predicated on rationality, right? So what this basically means is deterrence says, under deterrence theory, that before you commit a crime, you basically sit down and make a pros and cons list as to committing the crime. That doesn't happen, like ever, right? We know that people are irrational beings. I mean, think about even like your latest breakup, right? Like how rational were you following that? It's really difficult to say that people are rational. That being said, we assume people are rational, and deterrence seeks to prevent future crimes. So as you'll recall, there are two types of deterrence. There is general deterrence and specific deterrence. General deterrence is basically you're making an example of the offender, and in doing so, you're preventing crime, that same crime, from others in society, right? So if we want to talk about the death penalty being general deterrent, the idea here is, look, if you kill someone, we're going to kill you back. And that might encourage people not to kill people. Now, there's actually really interesting data and studies on this that suggests the death penalty might actually cause more violent crime than it actually prevents. And there's a whole lot of reasons for it that we won't get into, but there are some interesting studies. Now, that being said, this is the same thing as true as imprisonment. This is absolutely true when you talk about prisoners who are in orange jumpsuits on the side of the highway picking up trash, right? Are they doing it to keep the roads nice? Sure. Yeah, let's say they are. But in reality, it's people driving past going, oh my God, if I commit a crime, I could be out there in an orange jumpsuit in the extreme heat picking up trash, right? So like there is that general deterrence aspect. Now, the other type of deterrence that we look for is what's called specific deterrence. And this is preventing the individual from reoffending. Right, so whereas otherwise we're looking at society and making sure other people don't reoffend, in this case, we're looking at the offender and making sure they don't reoffend. Now, as I mentioned earlier on the death penalty, there's kind of some issues when it comes to general deterrence. The death penalty, when it comes to specific deterrence, is 100% effective, right? Like, that person's dead. They are not committing another crime. Granted, they're also not given the opportunity to prove that they're not committing another crime, but they are not committing another crime. And in specific deterrence, really what we're looking for is, look, this is how horrible life is in prison, or this is how bad probation restrictions can be, what have you, so that once they get released, if they're going to commit the same crime again, they stop, pause, and go, I don't want to go through that again. I'm not going to reoffend. Now, again, this is predicated on rationality. So that being said, there are, at least criminologically, 3 considerations for effective deterrence, right? So first is severity of the punishment. Now, unlike retribution and lex talionis, severity of the punishment is this concept, basically, the more severe the punishment, the more likely it is you're going to deter the general population and you're going to deter specific individuals, right? So let's say that you could receive the death penalty for going 5 miles over the speed limit. I guarantee you, everybody will be going the speed limit, right? But the problem is it's so disproportionate to the offense, especially since it's a civil offense, that it's unrealistic. So the idea is here, the severity should at least match the severity of the crime, but unlike retribution, if giving a much harsher sentence than is needed under retribution stops more people from committing a crime and stops the individual from committing another crime, then we're going to say, let's go with a more severe punishment. There also has to come into consideration the certainty of punishment, right? And this is a little bit of a problem in the American system because you're never certain that you're ever actually going to be punished, right? So, as I said before, if you commit some low-level misdemeanors, chances are your first time out, you're probably going to get probation, like a slap on the wrist. We give you like 1 or 2 bites of the apple before we really start punishing you. Now, and you're never certain of punishment. Like, we don't have a going rate for everyone. We recognize individual circumstances are different, individuals are different, et cetera, et cetera. So we don't necessarily have a going rate. So certainty of punishment, that is an issue in the United States. What's a really big issue in the United States is the swiftness of punishment, right? So let's say you're at a guilty plea, your guilty hearing and a sentencing hearing. As soon as you enter your guilty plea, there will be 2 deputies standing behind you, waiting to put you in handcuffs after they hear what the judge sentences you to, right? And so if you get sentenced to imprisonment, generally speaking, your punishment is going to occur immediately. It's swift, right? Now, the problem comes, and again, relating it back to like the death penalty, you can spend 30 years on death row, right? And so the idea here is there's not really swiftness. It's not like in some iterations of the court system, especially back in England, that you get sentenced to death and then you walk right outside and they hang you. Here it's you get sentenced to death and you may have 30 years and it may get changed, so you're not necessarily certain of the punishment, etc. Right? So an effective deterrent, what we kind of see is the more severe the penalty, even though severity is one thing we consider, certainty and swiftness do go down. That being said, there's another problem with deterrence, and that's not all crimes can be deterred, right? So consider something like passion killings. Passion killings can't be deterred, right? A passion killing is you come home, and you find your significant other in bed with somebody else, right? And usually in passion killings, you kind of mentally check out. Like your brain kind of just shuts down. It can't process what you're seeing, right? The love of your life is having an affair and you've caught them in bed and maybe you caught them having sex or they had just had sex or whatever. And you just lose it, right? For lack of better words. And so you go to the nightstand, get the gun out of the nightstand and kill them both, right? Shoot them both dead before kind of coming to realizing what you did and going from there. Now, in this case, no matter how severe the punishment, because we know what effect the underlying predicate to the offense has on the brain, severity of the punishment is not really that big of, I mean, you could put the death penalty for every time there's a passion killing, and it's not going to stop it, right? Certainty of punishment, you're not concerned with that. What you're concerned with is, your brain is concerned with ending the trauma. And again, swiftness of punishment, again, your brain's not concerned with that. So that's where we have problems with deterrence, is not all crimes can be deterred. Right, so you could do lex talionis, but you would have a really big problem with deterrence. So again, this is another big one for the United States. Then we have rehabilitation. So rehabilitation is one of the kind of, it's an odd one out. And what it is the treatment of underlying social causes of crime, right? Including psychological disorders. So the whole point of rehabilitation is like deterrence to the degree of specific deterrence, because it focuses on reducing recidivism, right? Basically, rehabilitation, we say, okay, you committed crime X. Now in prison, we don't ever ask, why did you commit crime X, right? Under a rehabilitative model, that's our first question is, so why did you commit crime X, right? And the idea here is, if we treat the causes of crime, maybe poverty, maybe mental disorder, whatever it is, if we treat that, then you'll be rehabilitated. You can be a member of society again. You're not going to reoffend because we have dealt with and eliminated whatever the causes of crime were. Now, this is the hallmark of the Norwegian prison system, right? So as I've said before in this class, and I'll say again, I'm a prison abolitionist, but Norway is as close to perfect as it can get. So Norway, they have one maximum security prison. And in order to work there, you either have to have a bachelor's or a master's in psychology. And the guards are there not to prevent you from escaping. That's why they have walls. Instead, the guards are there to help address why you did what you did, right? And your whole day is not filled with sitting in a cell. The whole day is, you see the prison psychiatrist, you see the prison doctor, you go to individual therapy, you go to group therapy, you go to vocational skills, you go to educational skills, right? Your whole day is filled with treatment. And the idea here is, we look at each person as an individual and say, okay, what happened? Why did this occur? So we can fix it so it does not occur again. Now, rehabilitation obviously is very controversial because it sounds like you're rewarding prisoners, when in reality, it's probably, it makes you more sane than if you were to be, just sitting in your cell, but you lose even more of your time because you are literally just going from program to program to program to program. And the idea is, we set up these programs in such a way that we're going to make sure that when you leave, you don't reoffend. And what's interesting in Norway is the maximum sentence you can get for a crime is 20 years in prison, right? So if you recall, a while ago, there was a shooting in Norway. A man went to like a children's summer camp kind of on this island and shot and killed like 60 kids, right? He was sentenced to 20 years. Now, there are other provisions that can lengthen the sentence, right? If there's like mental issues that come into play. But nobody was upset about it except Americans, right? Norwegians were fine with it because it was the maximum sentence. And the idea here is if we can't rehabilitate you in 20 years, like we're not doing something right. So will this guy get out? Probably, unless they can't rehabilitate him, unless he has psychological issues, which to kill kids, like you obviously do have psychological issues that make you a danger. So you could be like the subject of civil commitment, but that's their model is, instead of retribution, instead of deterrence, we're going to fix you, fix your life so that you come back out, do it again. Like the idea is you can't undo a crime, right? Like it's been done. So how do we fix it so it doesn't happen again? Then the United States is a very big fan of incapacitation, right? So incapacitation basically is removing an offender from society with really little concern about recidivism, right? So whether they commit another crime when they get out or not, we don't really care. All we care about is for 15 years, you, a theoretically dangerous person, who are no longer among us, right? It is worth noting that this has very, very, very limited statistical support. And it's because if we just throw you into a cell, and let's say you have underlying mental conditions or there are reasons you committed the crime, they're just gonna get worse, right? Like it doesn't get better. It's not like you get thrown into a cell and you have like schizophrenia and your schizophrenia gets better. No, it gets much, much worse. But we don't care. Like we're just like, well, you're gone from society, and then when your time's up, we'll release you. And if you commit another crime, then we'll put you back and then incapacitate you again, right? So again, there's limited statistical support, but we do definitely see this in the United States. And one thing that we see kind of emerging slowly but surely is kind of the fifth philosophical principle guiding sentencing, which is restoration, right? And so what restoration does, unlike the other forms of punishment, is it looks at and says, all right, this is really a conflict between individuals, right? And the role of the justice system is to repair injuries through peace. All right, so the idea is if you go and smash somebody's window and you get sentenced to a year in prison, guess what doesn't happen? That window doesn't get fixed. Restoration is you fix the window. You do what you did. I mean, you make right what you did. And instead of like violence and things like this, in restoration, we're looking at peace, right? And so restoration, the system puts an active role on the victim, an active role on the offender, and an active role on the community. So a lot of times they'll engage in what's called a peace circle, in which an individual leads a group discussion, right? And only one person can talk at a time, and they have like a talking piece. And the offender always goes last because they sit next to the person who started it. And it allows the victim to tell the offender to their face what this crime did to them, what it meant to them, how it hurt them, what it's meant for their lives since. It allows community members to say, and this is what your crime did to us. It wasn't even just this person, but you committed a crime against us. Right, you were one of our own, and you turned against us, right? And it's made us scared. We won't let our children go out and play in the yard anymore. You made it so that our kids can't go out and play. And like it is very much the people talking to the offender. And generally speaking, the offender, and we're not really concerned about the Fifth Amendment at this point, they go last, right? And usually halfway through, they're in tears. So by the time it gets to them, they're like hyperventilating in tears. And here's where we actually see sincere apologies, with the notion that an apology is not enough, right? You've got to fix what you did. So it's what we do in the justice system in the United States is shaming, right? Like, you're an ex-con, you always get that moniker, like, it is what it is. Here, we emphasize positive shaming, right? Which is, look, we know that deep down you're a good person. You just made a bad decision. So we're not condemning you as a person. We're condemning the decision that you made. And we want you to become a part of our society again, but you got to fix what you did wrong. Right? And so the idea in restoration is, once somebody has fixed what they've done wrong, healed the injuries, whatever they've done, they are welcomed back into society, and they're no longer shamed, right? They no longer have the moniker of felon or ex-offender or anything like that. They're just back to being a community member. And restoration is slowly emerging. We definitely see this in the juvenile justice system. But in adult systems, it's working too. It's relatively new enough that there isn't too much literature on it, but the literature that is on it suggests that it's actually a very, very, very effective way of preventing recidivism and of dealing with and addressing crime. So let's talk a little bit about kind of the history of sentencing before we get into how we work in modern day sentencing. So history of sentencing, sentencing in the United States derived from English common law, right? Because we were all English at the time. So why rebuild a program when we can just take what's already in place, right? And because of that, the law emphasized harsh punishments, not imprisonment, right? So if you're talking early colonial America, we're not looking at harsh punishment, or we're not looking at imprisonment. We're looking at harsh punishments. So basically, anything that was deemed a felony, you could be executed for. Anything that was deemed a felony, you could be executed for. On the other hand, misdemeanors, we didn't put you in prison. We subjected you to corporal punishment. So maybe public whippings, restitution, having to repay the offender, and even humiliation, right? This is putting somebody in the stocks in the town square, letting people throw crap at them, and just, you know, being humiliated. That's for misdemeanors. So like they were not messing around. Now, this lasted until the ratification of the Bill of Rights in 1791, right? Specifically with the Eighth Amendment. The Eighth Amendment prohibits cruel and unusual punishment. And what it did is it emphasized imprisonment over corporal punishment and things like that. And it did so largely because of the Puritan style penitentiaries, right? So penitentiaries are called penitentiaries for a reason, right? Penance is the big part of it. And the idea from the Puritan belief is a crime is a sin, right? And if you follow in the light of Christ from the Puritans' belief, then you would not have committed crime. So you go to a place where all you are given is a bed and a Bible, and you basically sit there all day and memorize the Bible and read it and pray and ask for forgiveness. And under the system, it was an indeterminate sentencing scheme. So what it meant was the judge would say, 5 to 15 years in prison. What that meant was you could not be released under 5 years, but you could not be released, but you had to be released over 15 years. Anywhere in between, the prison could decide to release you once it believed that you had made proper penance, right? That you had squared yourself with God, that you'd come to Christ, what have you, right? Now, this idea of you just get a bed and Bible definitely kind of fell out of favor, even though we still use penitentiaries, right? Interesting, in the federal system, there are federal correctional institutions There's also federal penitentiaries, and penitentiaries are usually the worst places to go. Lots of places they've changed the term from penitentiary to correctional facility, but it's still a penitentiary. It's based on the scheme of, we're going to put you away until you can prove to us that you are no longer a threat. Now, this was an indeterminate sentencing scheme. Again, the judge gives you a minimum and a maximum, and you can do anything in between. The prison can release you anywhere in between. Now, this was significantly limited by cases such as Miller v. Alabama, which is a 2012 case, again, one that I encourage you to read as it is in your book. Now, that being said, what we see is during the 1970s, right, so following the criminal justice revolution under Chief Justice Earl Warren in the 1980s, the U.S. reversed its position on indeterminate sentences, right? And the reason they did this is because judges were given way too much discretion, right? So you've heard of like a hanging judge, right? So you might have person A in state A who commits crime A and receives a year in prison. And you may have person B in state B who is convicted of committing crime A, the same crime, and they receive 15 years in prison. Right, and so in the 1970s, we saw this giant disparity, right? And and attorneys, they knew, and they still do to this day, like what judge you get determines what sentence you're going to get. So if they drew a hanging judge, like they were just like, it's over for you. You're going to go to jail for a very long time. Other times they would have judges who were light, and that's the ones that defense attorneys loved. And again, the idea was that they would give lighter sentences. But it was so disproportionate and absolutely took into consideration race. It shouldn't have, but it did. And so if you were Black, the more likely it is that you would get a much harsher sentence for the exact same crime than if you were white. And we still see that to this day. But that was part of the reasons that we kind of saw a shift in the 1970s. And what happened is, instead of indeterminate sentencing, right, where it's like 5 to 15 years and the prison can let you out whenever you're ready, we got replaced with determinate, otherwise known as fixed time sentencing, right? And this is, you commit crime A, you get sentenced to X number of years, period. Right? The prison can't let you out early for good behavior, can't let you out early because you've shown penance. Judges don't have hardly any discretion, because the statute says you commit crime A, you get punishment A. You commit crime B, you get punishment B. And the idea here was uniformity, right, in sentencing. And what we did is we had a one-size-fits-all approach. Now, in theory, this sounds really good, right? Like, it seems like it's fair. But in practice, it turns out it's not really fair, because people have different motives, different reasons, different inspirations for committing crime, right? So when we talk about a one-size-fits-all approach, you could commit crime A, and your best friend could commit crime A, but you have different reasons behind it. A one-size-fits-all approach may be inappropriate, right? Like, so you both steal a loaf of bread. You steal it because your family is starving. This other person steals it because they are a kleptomaniac, and you both get the same sentence. Where's the inherent fairness, right? So like, we need judicial discretion, but we don't want too much. But at the same time, determinate sentencing were a problem. And what ultimately happened is, what this resulted in was the adoption of the USSG, the United States Sentencing Guidelines, which I'll show you a little bit later how they work, in which sentences were mandatory at the federal level, until we had United States v. Booker in 2005, which said that mandatory sentences using the sentencing guidelines were unconstitutional. And again, because one size does not fit all. So instead, where we begin now is we begin with the sentencing guidelines, and then judges have discretion within the guidelines to give higher or lower sentences. Right, so we kind of have found a middle ground is where we're at today. So what are the current options authorized under the United States sentencing guidelines? The first and kind of the go-to approach to the United States is imprisonment, incarceration. It's the go-to option for creating harsh conditions. It's led to overcrowded facilities, largely inspired by the Get Tough movement. You ever want to read a really great case, and this, I believe this is in your text, if not, it's on Canvas, read United States v. Bailey. This is about a prisoner who escaped prison because his life was in danger. He basically sent a letter to the warden, the governor, everyone saying, I'll turn myself back in once it's safe. And he gets caught before he gets to turn himself back in, but the Supreme Court still hears it and is like, yeah, you can escape prison legally if you are in immediate danger. But as soon as that danger is passed, you have to turn yourself back in. Right? So like there is actually a lawful way to escape prison. So it's a really, really good case. It's really interesting. The USSG also provides for intermediate sanctions. So it provides a variety of options based upon the need for control and rehabilitation. So we have community service, which is like symbolic restitution, right? That's like picking up trash on the side of the highway in bright orange jumpsuits. We have intensive supervision, parole, or probation, in which you have to check in with your probation officer every day. You have to do drug testing so many times a week. You have all kinds of curfews. I mean, there's all kinds of stuff that the probation officer imposes upon you, which makes your home basically your prison. Home detention with electronic monitoring is also approved. So this is where you have an ankle bracelet, right? And it has GPS in it, and it has set coordinates. And if you go past the places where you are allowed to be, it gives you like 20 seconds to get back into the place where you're supposed to be before sending an alert to law enforcement, who will promptly come and arrest you. Same is true if you tamper with it, or if you try to cut it off. It has a tamper sensor in it. It has GPS, so we can always tell where you are. It's actually fairly effective. And I'll say this, home detention, I think we've all seen maybe, and we'll see a bigger shift come in the future after COVID, right? With all of us being shut in during COVID, being quarantined during COVID, we realized how much staying at home can suck. Like it might be okay for a couple of weeks, but after a while, like you go stir crazy, right? And home detention is like, nope, you're staying inside your house for 3 years. Like that's it. Yeah, like that can be bad. Like not necessarily bad as prisons, but still pretty bad. Sentencing guidelines also recognize boot camps. Now, there used to be, especially during Vietnam, judges would give people an option, right? They could either go to jail for 15 years, or they could enlist in the military, again, especially during Vietnam, basically go over to Vietnam and kind of like take their own chances, but they would be free. And you'd be surprised how many people actually took up this notion of let's go to Vietnam as opposed to I don't want to go to prison. To that end, there's one funny story, is the Hells Angels, the notorious biker gang, actually wrote the federal government and volunteered, their entire organization volunteered to go to Vietnam, but with the condition that they were not to be restricted in terms of like following orders or being under somebody's command. Their idea is they were just going to go kill everyone like who wasn't on their team, and that would be the end of it. And the federal government said, thank you, but hell no, right? So what we see is we do have boot camp programs, and they are kind of, they run in tangent with prisons. They're not necessarily affiliated with the military. And the idea here is we condition you to be a part of the community, things like that. Intermediate sanctions can include shock incarceration or probation, right? So shock incarceration is where you are sentenced to probation, like, 2 years on probation. So that means you just 2 years, don't do anything else again, you're fine. But we might do a shock, right? And we might say for the first 3 weekends of your probation, you have to report to the jail and spend 2 or 3 nights in jail before the week so you can get back to work. And the idea is so you can see like, oh, wow, this is a place I really don't want to be. I'm not going to mess up again. And then we have suspended imposition of sentence. You might see this referred to as SIS. So SIS basically is, I am sentencing you to 5 years in prison, suspended. And what that means is for the next 5 years, you have 5 years of imprisonment hanging over your head if you mess up again. So like if you mess up again, you automatically go to prison for 5 years. And then we deal with the crime that you committed and sentence you for that. Now, this could be you are at 4 years, 364 days, and you mess up and you get caught. Guess what? You just spent almost 5 years with being scared of going to prison. Now you are going to prison for the full 5 years, in addition to whatever you just did, right? So the intermediate sanctions, depending on which studies that you read, they are fairly effective. And then of course there's probation. Probation is a sentence. It's different than parole. It originated in Boston in 1841. It was the idea of a shoemaker. And generally speaking, it's for low-level first-time offenders. There's almost always conditions attached, right? Like you report to your probation officer once a week or once a month. You have to fill out so many job applications per week and turn them in, things like that. And the notion is we're giving you a second chance, but we're going to structure it in such a way that your second chance is meaningful. We also have fines. Fines are problematic because they can lead to a never-ending cycle of incarceration. So a lot of jurisdictions charge you for your stay in jail. Like you leave jail, you get a bill. And let's say you can't afford to pay that bill. Well, then it goes to court and the judge can order you to jail until you can pay the bill. Well, if you can't pay the bill on the outside, you sure as hell can't pay the bill on the inside. And assuming you get to pay your bill and you get released, guess what? You get a new bill for the new incarceration. So it is a very much a big problem. We have restitution. Now, this is done somewhat in tongue-in-cheek because during criminal trials, the victim is not a victim, right? The victim is merely a witness. The state is actually the victim. So that's why it's United States v. Johnson or the state of New York versus Jones. The state is the victim, not the actual victim. That being said, restitution does generally go to the actual victim. This is often in the form of money, but courts can be creative to meet needs, right? And we actually look at Sharia law. Sharia law is really interesting. If you kill the breadwinner of a family, for the rest of your life, your salary goes to the family. And the idea is to make up for the fact that you took away the person who brought home the money, right? And like, so basically you have like two jobs. One job is entirely for them. One job is for you to barely get by on, but you should have done what you did, right? So again, courts can get creative. That's not a Sharia law, but even American courts can be creative. And then of course there's death, right? So one thing I want to say is people say, is death penalty constitutional? It is constitutional to the degree that the Constitution anticipates the death penalty. Right, so if we look at the Due Process Clause, it provides that, quote, no person shall be deprived of life, liberty, or property without due process of law. So when we challenge the death penalty, what we're really challenging is the application of the death penalty in terms of the methods, the crimes, and the individuals, what they raise, right? In terms of like who should it apply to, when should it apply, etc. Now this, under the Eighth Amendment, is judged under what's called the evolving standards of decency, right? And the idea here is as the country matures, generally we become less violent, and in so doing so, we have less tolerance for violence, even if it's imposed by the state. And would it turn the stomach of somebody to do this? If so, then yeah, it's probably a violation. So that's kind of where we're at in terms of the death penalty. And USSG also provides for civil forfeiture. So civil forfeiture is kind of a newer concept. It's a cruddy concept, but it's a newer concept. And what it basically is anything that you use to commit the crime or to facilitate the crime or to have really any relation to the crime can be seized by the federal government. And it is presumed, the property is presumed criminal unless you can prove that it's not, which you never can. And then the government gets to sell off your property and keep the money. So this is why if you ever enter, whenever you graduate and you get an apartment, you'll enter into a lease, and your lease will have in it a provision about drug use and apartments and things like that, right? Prohibited. And the idea here is the apartment complex is trying to be able to show that if you use your apartment for drug dealing and you get busted, theoretically the government, even though you weren't the one, if you're the owner of the apartment complex, you weren't the one dealing drugs, the government can take the entire apartment complex and sell it. And so that's why you have this clause in most leases that talk about drugs and the use of drugs, and that it's solely you, and you're completely discouraged, and it can be a termination of the lease immediately. And the idea is to prevent the courts from going too far. Now, that being said, this doesn't necessarily happen on that scale. What we do see a lot of is forfeiture of people's vehicles, cash that they have on hand, things along those lines. Let's talk about the sentencing process for a minute. Sentencing process, it normally begins with the preparation of a pre-sentence investigation report, otherwise known as a PSI, by probation and the parole department. Right? And so what this basically does is the probation and parole department go into a very deep dive of your life, of the crime, of everything. And after an exhaustive investigation with you, your relatives, neighbors, all that stuff, this is especially at the federal level, they come up with a recommendation as to what your sentence should be. Right, so hopefully this does not freeze again, because I want to show you what one looks like. So this is a pre-sentence investigation report. It talks about the offense. It talks about if you're released, were there co-defendants, are there related cases, when did this occur? It looks at the date of birth, your age, your race, your social security number, your education, do you have any dependents, where are you a citizen, where's your address? Then it looks at the offense, what are the charges and the convictions, were there co-defendants, was the offense conduct, like what happened, basically like in the case, what did you do, what is the victim impact, was there obstruction of justice, have you accepted responsibility? And then they do an initial offense level determination. And we'll talk about why that's important here in a second. I apologize, everyone. It looks like it froze up on us again. That being said, I'll just kind of try to go through the rest of the slides, even though I don't think you'll be able to see them. Resume slideshow. There we go. Hopefully, you can all see this. If not, that's fine. But we compiled the pre-sentence investigation report. We come up with a base level offense, and then we come up with really an extensive investigation, and and the probation and parole recommends to the judge what your sentence should be. The prosecutor and the defense counsel then get to make recommendations on sentencing, advancing their positions. So what this basically kind of comes down to is the prosecution and defense can say, no, it should be more severe, or no, it should be less severe, just depending on the crime itself and its impact. Now, victims are given the opportunity by law to make a victim impact statement in which they tell the court and the offender what this has done to them, what it has meant to them, how it has hurt them, etc. And they can ask for whatever the hell they want to in terms of a sentence, whether it's a legal sentence or not. And that has a really big impact on the judge. But something that has the biggest impact on the judge, which is not guaranteed, but happens at the federal level, and most states do this, is what's called the offender's allocution. The allocution is where the offender, after all this happens, gets up before sentencing and apologizes for the crime, talks about why they committed the crime, talks about and what they want to do to better themselves, all that jazz. Now, in reality, you would think that this does not necessarily have much of an impact, right? Because the person is guilty, of course they're going to apologize. They're trying to get out of trouble. What's interesting, I had a class who was taught by a judge, and he said, or she said, that the allocution is a federal judge, and she said the allocution for her is what was one of the biggest determinations as to what sentence she was going to impose. And the reason behind it was, she said, if it's allocution, the offender gets up, apologizes, whatever, there's nothing really to it. Like, okay, whatever. You're going to go with the sentence that you walked in thinking you're having. But she said that she walked into sentencing where she thought about this person and she knew she was going to drop the hammer on them. Right? She knew that she was just going to obliterate them. So she gets into it, and then she figures out that the offender gets up and does his allocution, and the offender is crying, and the offender is sincere, and the offender genuinely feels terrible. The offender, is legitimately remorseful. And she said that she has dropped sentences down years. Sometimes she'll go from prison to probation because of an offender's allocution, right? Because did this actually register? Did this person do what they were supposed to do? Do they actually feel this, or are they faking it? Now, that being said, judges combine this information with the law. So at the federal level especially, there are mandatory minimum sentences. So it's like a minimum of 5 years in prison is usually the go-to in federal prison, or federal proceedings, I should say. There's also usually a cap, right? So not more than 20 years. And in between that, the judge has discretion. Now, this is generally limited by the U.S. sentencing guidelines. So I'm going to try to show this again. We will see if it works. Hey, it worked this time. All right, so we're back. This is what the U.S. sentencing guidelines look like in terms of a table. Now, this is the federal level, and all the numbers that you see that aren't in bold are months. So in prison and federal cases, you get sentenced to X number of months in prison as opposed to years in prison where you see at the state level. Now, like when you hear it, sometimes it doesn't sound that bad. You're like, oh, 60 months in prison? No, that doesn't sound terrible. Then you realize, oh, wait, that's 5 years. Like that's pretty bad. So what we do is basically every crime under the federal code is assigned an offense level, right? So the more dangerous the offense, the higher the offense level is going to be. Now there are add-ons and things like that that we can tack onto it. Then, once we know the offense level, then we calculate somebody's criminal history, right? So how many times have they been in trouble before? Have they been convicted of 2 or more felonies? Have they been convicted of 3 felonies? Have they been convicted of 0 felonies? Have they been convicted of 13 felonies? Right? So we look and see like how many chances or how many bites of the apple they've been given. And then all we do is we just scroll down to where the 2 lines meet, right? So let's say somebody has they commit an offense level of 15, right? So we go down to 15 and we say that this is the first time they've ever been in trouble. Now, subject to mandatory minimums, this tells us that we can sentence somebody to between 18 and 24 months in prison. And generally speaking, the judge will set an actual number, right? So 19, 18, 20, whatever they decide, they'll set a number, and that's how long the person will spend in prison. Now, federal prisons have largely gotten away from parole. There are things like good time that kind of like will help whittle this down a little bit. But this is where the judges have discretion, right? They have discretion to impose 18 to 24. Now, they can go above the 24 and they can go below the 18, as long as they meet the mandatory minimums and the mandatory maximums, right? But if they do so, they have to put in written document all of the reasons that they decided to deviate from the guidelines, right? To go above or to go below. Now, generally speaking, if you go above, it's always going to be appealed. If you go below, it's never going to be appealed. Even though prosecutors can appeal a sentence, they cannot appeal a conviction, right? So if it goes below, if the judge is like, you know what? Yeah, this was a 15 level offense. I mean, it's like, so it's kind of in the middle. It's a little bit less than the middle. Not horrible. It's a zone D offense. It's your first time doing it, but you know, you had reasons. I understand those reasons. You know, I'm just gonna put you in 12 months. Usually what you'll see is 12 months and a day. Because if you are sentenced to 12 months, you serve 12 months day for day. If you are sentenced to anything more than 12 months, so 12 months and a day, you are eligible for good time. And good time is basically every day that you spend in prison that you do not reoffend, or that you do not break prison rules, I should say. Your day counts for like a day and a third, right? So basically, if you go 3 days, you've gotten an extra day off your sentence, right? So judges who are trying to be merciful will sentence people, if they can't sentence them to probation or something like that, to a year and a day. All right, so 12 months and 1 day in prison, so that they're eligible for good time. But as you can see, the more severe the offense, the more we see these numbers creep up, right? Offense level of 32 with a criminal history score of 1 gives us 121 to 155 or 151 months in prison, right? 43 is down to life, and life can include death. So the same is true as we go over, right? So if you have a 15 level offense, it's your first offense, 18 to 24 months, If you're a repeat offender, 41 to 51 months, right? So these things really do matter. So I'm going to see if I can reshare PowerPoint. Okay, so what I want to show you is just an example of how this works, right? So for instance, let's say that we have a person charged with providing or possessing contraband in prison, right? So you have some kind of contraband in prison, whatever it is. You have a base level offense of 23 if the object was a firearm or a destructive device. You have a base level offense of 13 if the object was a weapon other than a firearm or destructive device, any object that might be used as a weapon or a means of facilitating escape, ammunition, LSD, PCP, methamphetamine, or narcotic drug. You have a base level offense of 6 if the object was an alcoholic beverage, United States or foreign currency, a mobile phone, or a controlled substance other than LSD, PCP, and methamphetamine. And they have a base level offense of 4 if the object somehow otherwise threatened the order, discipline, security of the institution. So let's say that you smuggle in a cell phone into prison for a prison inmate. Well, that tells us, if we go down our list, you smuggle in a cell phone. So a cell phone is governed by, you have a base offense level of 6. All right, so if we kind of go back to our level or our table, we know we have a base level offense of 6. All right, so this is where we start. And then we look at the person's characteristics, right? Like how many times have they offended in the past, things along those lines. You can see that smuggling a cell phone, you might not even, you probably get a slap on the wrist if it's your first time. So that's kind of where you're at. However, we do also consider other special characteristics. For instance, there's a special offense characteristic. If the defendant, so the person who smuggled in the cell phone, was law enforcement or a correctional officer or employee or an employee of the Department of Justice at the time of the offense, we increase their offense level by 2. All right, so we go from a 6 to an 8. As you can see here, 6 to an 8, not that big of a jump when we're talking offense levels. But as we kind of progress down the chart to criminal history, you have 2 to 8 months suddenly becomes 6 to 12 months, right? So this is how we calculate it. And the judge can sentence anything in between 6 to 12. It's presumed reasonable, and it's not subject to appeal. They want to deviate, if they want to go above or they want to go below, they do have to appeal. Or they can appeal, I should say. But the judge has to give written explanation as to why they have very good cause to deviate from the sentencing guidelines. So sentencing guidelines are no longer mandatory, but they are our starting point. So that being said, next class, our final class together, we are going to look at appeals and habeas corpus. As always, if you have any questions, please feel free to email me and we can go from there. Have a great day.